The year is 1510, Autun, France. A black cloud of locusts descends from the sky, stripping the once lush vineyards bare in a matter of hours. The sound of millions of jaws chewing through leaves echoes like a low thunder. Yet, to the people standing in the ruin of their livelihoods, looking up at the darkened sun, this isn't viewed as a natural disaster. It's perceived with deadly seriousness as a criminal conspiracy. When faced with the absolute destruction of their crops, these winemakers don't immediately reach for fire or poison. The devastation is absolute, the hunger looming. Yet they pivot to an entirely different kind of weapon. They reach instead for the cold, rigid authority of a formal legal summons. A swarm of locusts wasn't just an act of nature. It was an organized, malicious syndicate that needed to be brought to justice. This mechanism was known as the Exorcism Protocol. And this wasn't a metaphor. It was a formal, technical, and exhaustively expensive legal battle waged against the animal kingdom to reset the divine hierarchy. This protocol treated beetles, locusts, and weevils as legal persons entirely capable of sin. It represented a desperate, profound attempt by medieval society to domesticate a chaotic universe, a world where the boundary between man and beast frequently and terrifyingly blurred. To grasp this, you have to understand that in the medieval mind, nothing happened by accident. There was no such thing as random chance. A plague of weevils gnawing at the roots of a harvest was perceived as a defective part of the divine machine. It was an error in the moral fabric of the universe, requiring a strict, methodical, procedural correction rather than mindless extermination. The court's machinery moved with absolute gravity. It advanced from the villagers filing formal complaints of wanton destruction to a surreal spectacle. An official of the court, dressed in full bureaucratic regalia, would stand in the center of the devastated, infested fields. Surrounded by the clicking and crawling of the accused, the official would solemnize a reading of the summons directly to the dirt. The insects were formally commanded to depart and, adhering strictly to the law, they were given 3 distinct opportunities to appear in court and plead their case. But what happens when the defendants inevitably fail to show? When the insects ignore the 3rd and final summons? The court didn't simply default them. That would be a violation of their rights as creations of God. Instead, the court armed them with the greatest legal minds of the age. Enter Bartholomew Chasseneuz. He was a legendary 16th century jurist who built his entire formidable reputation by doing one thing: defending rats. In one of the most famous cases of the era, the rats of Autun were summoned to court. When they failed to appear, Chasseneuz delivered a procedural masterstroke. He stood before the judge and argued that his client's summons was entirely null. Why? Because the journey to the courthouse required the rats to pass through the village, running a gauntlet of their mortal enemies, the village cats. How can a defendant be expected to safely travel through a literal gauntlet of assassins? Recognizing the absolute legal validity of this argument, the court was forced to adjourn. The defense lawyers appointed for these creatures were not pettifoggers or junior clerks looking for amusement. They were apex legal scholars. They were experts wielding the Corpus Juris Civilis and the St. Louis establishments with surgical precision, applying the highest standards of human law to the lowliest of crawling things. A profound theological clash naturally emerged in the courtroom. The defense would stand and rest their entire case on the book of Genesis, arguing flawlessly that God granted every green herb for meat to all creatures. The insects were simply exercising their divine right to eat. This created a terrifying logical loop. You see, prosecuting the insects meant legally cursing the creator who gave them the right to the harvest. To break this loop, the prosecution was forced to escalate. They branded the animals not as natural creatures, but as demonic living corruption, monstrous aberrations explicitly excluded from Noah's Ark. By categorizing the insects as demonic, the court opened the door to a higher, more absolute authority. If physical interventions like fire and steel failed to clear the fields, the era of divine pesticide relied on holy water. It relied on the ultimate metaphysical eviction notice, the terrifying weight of excommunication. To truly understand the mindset of this era is to recognize a completely different scale of consequence. A modern courtroom cites a statute every 180 seconds just to manage the flow of human commerce and crime. But a 15th century court, they cited the eternal soul. The law wasn't merely a tool for order, it was the architecture of salvation and damnation, applied to humans and insects alike. Yet, even within this rigid, unyielding system of divine and legal retribution, the courts occasionally showed surreal, breathtaking mercy. In 1519, a judge in Stelvio presided over a case against field mice. Acknowledging the natural state of the defendants, the judge legally granted 14 days of grace specifically for the pregnant mice and the very young, allowing them time to safely vacate the commune before the full weight of the law fell upon them. The absolute earnestness of this legal fiction reveals a society striving for perfect justice.
The ultimate consequence of these trials was the anathema ritual. This was pronounced with heavy solemnity only when the pests refused to vacate, after all legal avenues were completely exhausted. The anathema was a brilliant, perfect judicial trap. If the insects disappeared, the curse succeeded, and the church's power was validated. But if the insects remained, the legal framework held that the villagers themselves were at fault. The pests were a divine punishment for the villagers' own unpaid tithes or unconfessed sins. It was a metaphysical failsafe, ensuring the authority of the court could never truly lose.
The absolute peak of this procedural machinery struck not in the fields, but in the village square. It moved violently from the abstract metaphysical realm of swarming insects to the visceral, bloody reality of murder.
The evidence in the 1457 Savigny case was gruesome. A 5-year-old boy was found killed, a sow and her 6 piglets were caught nearby, covered in blood. The animals were arrested, jailed, and tried just as humans would be. After a meticulous trial, the sow was convicted and publicly hanged by her hind legs in the town square. But the piglets were legally acquitted. The court reasoned their youth made them vulnerable to their mother's corrupting influence. Cleared of murder, they were formally reclassified as vacant property and forfeited to the Lady of Savigny.
The sheer expense of these trials was staggering. Communities literally bankrupted themselves hiring lawyers, scribes, and judges to prosecute pigs and weevils. They did this not out of madness or mass hysteria. They did it to silence the outcast's laugh. They did it to assert cognitive control over devastating, inexplicable tragedy. By forcing a beast into human clothes and granting it a formal day in court, a random, bloody tragedy was transformed into a rational, orderly story. When a child dies by an animal's teeth, or a town starves because of a swarm, the universe feels entirely out of control. But a courtroom has rules. A courtroom has a judge, a defense, and a verdict. The trial domesticated the chaos. The Exorcism Protocol served as the psychological bridge in the medieval mind, providing the vital illusion that even the senseless, even the most violent and unpredictable elements of nature were ultimately subject to the King of Heaven. Through the lens of the law, the animal was a thing, but it was also a person. It was a machine, but it was also a moral agent. But this isn't merely a quirk of medieval history. The legacy of these trials, the deep human need to categorize the moral agency of the natural world, completely outlived the Middle Ages. It appeared as recently as 2011 when the Swiss canton of Zurich employed a publicly paid lawyer specifically for animals. The fundamental boundary between property to be owned and persons to be defended remains entirely unresolved. The philosophical tension of Autun and Savigny persists in the invisible structures we enforce today. As we look at the legal mechanisms of the present, the question echoes from the 15th century. Is giving a dog a lawyer more or less civilized than our modern system of summary euthanasia? The philosophy of medieval animal trials stands in stark contrast against the cold efficiency of the present. The court is still in session.